I know most of you, but for those I don't know, I'm Hugh Delios. I'm the director of the journalism program at the Joyce Foundation. It's an honor for me to introduce this next panel discussion. It's focused on the fallout from the legal ruling that doomed the Fearless Foundation's grant program for businesses owned by Black women. The ruling portends a potentially significant shift in the legal landscape surrounding charitable giving in the U.S., and it raised important questions about the future of philanthropy, especially when it comes to supporting communities of color and advancing racial equity. In response, a number of funders have reviewed their own giving for implications, and many are looking for guidance about the way forward. This panel will examine the potential impact on media and journalism philanthropy and discuss strategies for navigating the legal pitfalls while continuing to promote racial justice. Please join me in welcoming today's panel. Moderator Mina Kim, host of KQED's Forum, along with Kiara M. Bridges, Carlicia Graham, and Martin Reynolds.
Oh, you're playing Forum's 10 a.m. theme music right there. That's so lovely. I'm Mina Kim. I'm the co-host of KQED's Forum program, our live call-in, live comment-in news and culture talk show. Yay, listeners, thank you if you are one. And it's really a pleasure to be able to talk with these three incredible people today about a very difficult topic, which is essentially media grant making in a changing legal landscape. And you got a lovely sort of overview of that from Hugh just a moment ago. So let me give a little bit more information about the panelists sitting here with me. Kiara M. Bridges is professor of law at UC Berkeley School of Law. Professor Bridges has written many articles concerning race, class, reproductive rights, and the intersection of the three. Her scholarship has appeared in the Harvard Law Review, Stanford Law Review, Columbia Law Review, among others, and also is the author of 3 books, Reproducing Race and Ethnography of Pregnancy as a Site of Racialization, The Poverty of Privacy Rights, and Critical Race Theory, a Primer. And Kiara, I learned, is a classically trained ballet dancer as well. So welcome, Kiara. Thank you. Carlicia Graham is next door, president of New Media Ventures, an investor, startup mentor, serial entrepreneur working at the intersections of technology, culture, and politics. Her work centers on getting capital to people who are reimagining and building a greater future, a thriving democracy, responsible tech, a responsible tech ecosystem, and equal capital opportunities for underinvested communities. Welcome, Carlicia.
Thank you.
And Martin Reynolds is co-executive director at the Maynard Institute and oversees fundraising, client relations, and external affairs, and serves as the Robert C. Maynard Institute of Journalism Education's lead Fault Lines diversity trainer. He's the co-founder of Oakland Voices and a professional lyricist as well. Welcome, Martin. So, Kiara, let me start with you for a reminder of what the legal challenges against the Fearless Fund were. Who brought them? Why?
Great, yes, absolutely. So happy to be here, and I have notes with me because as a law professor, I tend to be verbose, and so my notes sort of keep me more pithy in my statement. So the American Alliance for Equal Rights versus Fearless Fund, in that case, the 11th Circuit granted a preliminary injunction against a venture capital fund called Fearless Fund, and Fearless Fund had held something that they called a Fearless Strivers Grant Contest, which allowed businesses owned by Black women to compete for a $20,000 grant. And the 11th Circuit held that the funding competition likely violates Section 1981, and Section 1981 prohibits private parties from discriminating on the basis of race in the making or enforcement of contracts. One of the primary issues in the case was whether the contest constituted a contract. If no contract was created between the foundation and the competition winners, well, then Section 1981 would be inapplicable. And the court found that the funding competition did, in fact, create a contract between the foundation and the competition winner. And they found as much in part because up until the point that the American Alliance for Equal Rights sued the Fearless Fund, the fund itself had described itself as creating a contract between itself and the winners. It had explicitly said that in exchange for the $20,000 grant and mentorship from the program, the winners would allow the foundation foundation to discuss the winner's ideas, as well as use the winner's name, likeness, and image in promotional materials. And that's a classic bargain for exchange that constitutes a contract. Now, the other primary issue in the case was whether the foundation came within an exception in anti-discrimination law that allows organizations to, for lack of a better term, discriminate on the basis of race when they are instituting a remedial program. And a classic example of a remedial program that would come within the exception to anti-discrimination law is a race-conscious affirmative action program that is designed to address what the jurisprudence calls a manifest racial imbalance in an organization. And in the Supreme Court case in which the court established the remedial program exception, the court said that in order not to run afoul of anti-discrimination laws, remedial programs ought not to, quote unquote, create an absolute bar to the advancement of other employees. And the 11th Circuit held that the Fearless Fund competition did not come within this remedial program exception because the competition created an absolute bar to entrants who were not Black women. Essentially, if you weren't a Black woman, you cannot win a grant from the Fearless Fund. So that is sort of the Fearless Fund case, but I want to back up. I have a couple of minutes to set the Fearless Fund case within a larger context. And I would say that the relevant context for the case begins in the summer of 2020 after the police killed George Floyd in the middle of broad daylight in Minneapolis. And as many of you all sort of vividly recall, Floyd's murder sparked a long, hot summer of racial protests in 2020. And shortly thereafter, in fall 2020, the Republican Party discovered this thing called critical race theory. They started talking about it nonstop. And they said that critical race theory was being taught everywhere, K through 12 schools, government agencies, other institutions across the country. And they proposed that this critical race theory posed an existential threat to the nation, insofar as it sort of taught implicitly white children and adults to hate themselves and their country. And so they attempted to eliminate this threat of critical race theory by engaging in a concerted, focused, and I should add, well-funded project to root out this critical race theory from the nation's institutions. Now, I wouldn't be me. I wrote a book called Critical Race Theory, a primer. It came out in 2018, which means that it came out before the Republican Party even knew what critical race theory was. And critical race theory that the Republican Party has been talking about is not the critical race theory that existed for 40 years prior to the Republican Party's discovery of it. The critical race theory that existed was born in the 1980s is an advanced legal theory that attempts to theorize the role of law and continual racial inequality in a country that purports to at least embrace formal equality. That was not what the Republican Party is talking about, but be that as it may, scholars have shown that the recent attempts that conservatives have made to rid the country of CRT is part of a larger war on woke that seeks to delegitimize scholarship that foregrounds questions of race and racial justice. And this war on woke seeks two things. First, it seeks to prohibit the teaching and learning of concepts that individuals living in a secular, multiracial democracy might need to know if the democracy is to be successful. And these are concepts relating to race, gender identity, sexual orientation, and so forth. And second, the war on woke seeks to describe the U.S. as having triumphed decisively over racism, right? It seeks to convince everyone that racism exists today only in policies and programs that woke liberals pursue in order to address racism. Programs like race-based affirmative action, programs like implicit bias trainings, lessons in K through 12 schools that teach about this country's history of racial disenfranchisement, and of course, competitions like the Fearless Strivers Grant Contest. I'll end by mentioning that the war on woke sort of gained steam last year when the Supreme Court decided Students for Fair Admissions versus Harvard and UNC, in which the court struck down Harvard and UNC's race-based affirmative action programs. Students for Fair Admissions versus Harvard was a narrow decision. The most important thing I want you to take away is that the court did not overturn a 2007 precedent called Grutter versus Bollinger when it decided Students for Fair Admission. Grutter versus Bollinger says that race-based affirmative action can be constitutional if they exist in order to pursue the educational benefits that flow from student body diversity. So the court left Grutter in place. It was a narrow decision, and so that is the context for Fearless Fund.
Is it also notable that Fearless Fund settled with the American Alliance as well, meaning that they didn't have some kind of ruling that would be based on the merits of the case?
Absolutely. So the fact that Fearless Fund settled means that the 11th Circuit's granting of a preliminary injunction is sort of like final. And so what that means is that we can't create the conditions for a circuit split. So for example, the 9th Circuit holding that a race-conscious grant competition might be constitutional under Section 1981. If the 11th Circuit held one thing and the 9th Circuit held had a different decision, that's a circuit split that can go up to the Supreme Court. And the fact that the Fearless Fund settled means that we don't have that circuit split, creating the conditions for the court to weigh on. Now, the last thing I'll say, we don't want this court to weigh in on it, so it might actually serve purposes that are good.
And yet, it seems to have had a chilling effect on grant making, this idea that you cannot specifically do a grant program for Black women, for example. So I'm wondering, Carlicia, what you've noticed in terms of whether or not it's had an effect, and also whether or not you felt that at New Media Ventures you had to navigate this decision in some way.
Yeah, it had the effect of doing the opposite of actually the fund. The fund is Fearless Fund, and it created the atmosphere for fear-based capital allocation. And so what we're seeing across the landscape, both in traditional philanthropy and in venture capital, is folks making decisions based out of fear. Fear of being sued, fear of being the next on the chopping block. They don't support their grantees in the same way they used to. And I don't want to at all sort of say folks aren't doing work behind the scenes, that they're just not loud about it. So it's create this culture of silence is creating the opportunity for us to go back to our old ways, which is grant making inequities, right? We're not doing anything to preserve the work that we've done particularly over the last 4 or 5 years, to make sure that we are helping to close the race equity gap in meaningful ways, in loud ways. So without any backstop, any accountability measures, funders themselves get to decide how much they want to lean in and how to lean out. And so we're seeing across the board people leaning out, and they can get away with it because there's no measure to sort of support it. So for us, what it does is it made us look at our internal processes. NNV does not have a race-conscious mandate. We do have preference based on the impact and outcomes that people of color as founders tend to produce, which allows us to fund in that way. Our portfolio, sometimes it's like 70, 80% people of color led. Again, it's based on outcomes, not on race itself. But what we're seeing across the board is that people aren't doing the work to make sure that they are protected against said attacks. They're just afraid of them. And I'm so happy we have a legal scholar here today, but she'll tell you that this was a very specific case, like whether it's like creating an actual contract, the district they were in, the types of funding they gave. Like this was a very specific case, which is why they went after this very specific type of funder. You don't, as funders, don't face the same threat. You might have some threat, but this is where you talk to your attorneys. This is where you talk to your grant teams. This is where you find out where you're vulnerable, shore those up, and then get out there and continue the fight, even louder than you were before. Because when you're loud, it gives smaller funders and intermediaries permission to do so as well and to stay the course. And so what we need is funders who are loud about it, who are sure that they're right. You are in the right, but I can back it up because I've talked to my attorneys, I know my vulnerabilities, and I can go out there and support my grantees. I can go out and support the work that we do that we know is backed up by actual data that we need in this world.
Yeah. So we're hearing that you can fight. There are a lot of legal avenues. There's a lot of very specific conditions in this particular ruling. And yet, what did you notice, Martin?
Well, similar to my colleague, I think the thing that concerns me most as I think about this, and I look at this really from two perspectives, one personal and the other professional. And personally, coming as a transracially adopted, biracial, Black man who comes from a family that's multiracial, multi-ethnic, multinational, I don't get to turn away from this reality every day, nor would I want to. And I don't have the luxury of turning off who I am and who you see every day. It's why the work of the Maynard Institute, where we support journalists of color so that they can thrive and contribute to this craft that we love, this democracy, this nation, and this world. And so when I think about this, and when I do these trainings in news organizations, I will often ask, well, what is your relationship to racial diversity, to a room that is often mixed? And I realized, and started asking this question because I realized that certain people don't have a relationship to it. Much like I don't often think about my gender. Certain people don't think about their race. And it's essential to be mindful of that. And the other part that stands out to me is the words that we use. Because when you change the words, you change the story. And so in a room full of media funders who are supporting journalistic enterprises, when the words get shifted, softened, or a portfolio gets nestled within a portfolio of compassion, rather than being explicit about addressing racial equity, the disparities persist. And my question is, what are the unintended consequences from changing the words? As a lyricist, the slightest turn of phrase changes the rhythm and cadence of a song. As an editor, the slightest change of word changes the entire context of a paragraph. And so it is incumbent upon the philanthropic community to say the words and to address this issue explicitly. It is like writing a story about infant mortality and not contextualizing the health disparities that Black women suffer. And so as I think about, and I also think about some years ago, I was part of a fellowship to address challenges. And as part of our challenges, we had to be very explicit about the words that we use to describe the problem. And so if the words that are being used are not explicit, also for those who have millions, tens of millions, hundreds of millions, or billions of dollars, to be reticent to step forward and instead leave it to organizations like my colleagues here or the Maynard Institute or publishers or others, I find that to be problematic and cowardly. And I'm just going to be real about it. So to me, step forward, step up, and double down in service of this issue.
So what would be your response, Barton, to a funder that's saying we're going to be a target because we are big, because going after us would make headlines? What would you say to that?
I would say the targets are folks of color, Black women, people of color. Those are the targets. And if you've got the money to withstand, I think there's an obligation to stand before grantees, not simply behind them, mistressing the approach to grant making and racial equity, or consorting, so that we have the masculine and feminine.
So you're saying that these big, well-resourced organizations are in a better position to be risky because of it, because
Absolutely.
of their size.
And I want to say I appreciate that money is still going to fund organizations like ours. It's going out the door. So that's appreciated, but the words matter.
And I think that's really what we're getting at here is we're hearing that it's had a chilling effect, but really trying to get at this question of should it actually have a chilling effect? And essentially what I'm hearing all of you say is that it shouldn't. But I think the big question then is, so then what does fighting back look like for a grant-making organization, right? One example you've given, Martin, is don't change your language, right? Be explicit about what you're doing, and because it's very important. The consequences of softening or hiding that are much bigger than you probably realize. But I'm curious, Carlicia, what you think of in terms of, what does real allyship look like in this space without putting the burden on grantees and the very communities that are being targeted by this?
Yeah, absolutely. Don't shift the burden. You talked about taking the hit. I think that's super important. Take the hit. you can withstand it. I think actually Margaret Casey does a really good job of standing in front of their grantees. I love the work they do and how they support their folks. For me, I think it's two things. It's one, understanding that this is an interdisciplinary fight. We are used to, as media funders, journalism funders, we're used to fighting in the business community, in the tech community, in the publishing space. We are not used to fighting in the legal space. This is not an isolated incident. Folks will continue to come because it's tied to democracy. And there are people in this world who don't want us to have a multiracial democracy. They don't want people to have equal access, equal voice. So we can't just think about it as a media lens and an information flow. There's a legal aspect to this. So if you have a pro-democracy program, do not just think about it in terms of your media grant-making side. You have to talk to counsel. There's a part of this which is like really tied to our federal judiciary. Across this country, which is our backstop. And they're not just coming for grant making, they're coming for everything that is tied to a better, brighter future for all, right? And so like if we want to advance, we've also got to be looking at this and playing a long game of like how do we hold the line in that space. I think secondly, or even tied to that, when I think about this case, I think about Plessy v. Ferguson. You all know this ruling, right? Which set the precedent for separate but equal. 60 years later, Brown versus Board of Education came. It took them 60 years to reverse that precedent, right? Now, I don't think it's gonna take us 60 years to make sure we get, I hope so, otherwise, what the fuck? But we've got to be prepared for the fight. Right? We can't look at this as a short-term thing or a short-term threat, even though they settled and they're now providing like loans. We can't say that this fight is over. It is not over. It is all of us. We have to also think about our pro-democracy programs as advocacy programs and fights bigger than sort of that arena. And I think the second piece is beyond just like showing up for folks, it is making sure you're not passing this work along to your program managers, particularly your Black and brown ones who are focused on running program and are not legal experts and they're not like, they should not be playing in this sort of like lane. Even this conversation, as much as I love Vince and your team, like white folks need to be involved in this program as well, right? Like we need to be upfront talking about these issues because it affects you as well. We talk about rising tides lift all boats, that it's true in this case. Like it is not a Black versus white thing. This is a democracy fight. And if they come for you, they'll come for everybody else, right? And so if we can make sure we're carving out spaces in our organizations for people to take on this work and we're not just shuffling it to people with darker skin or people who have already overloaded plates, that expertise does not extend to this type of work. And so that is what I will also offer is if you can bring in some structural capacity in your teams to help as you progress in this space and not pass it to someone else that doesn't necessarily know how to steward it.
And I think just before the end of this session, we are able to take a couple of questions from the audience if you have them. So think of them. And let me just ask Kiara, though, just in this space legally, what message do you want to leave funders with regard to what they can do within this space? What can they still do? Because I know you've had some disappointment with regard to how some entities have, interpreted students for fair admission and that decision as well. So what would be your advice in terms of what it is that funders can still do and maneuver,
right?
How they can maneuver in this space?
Yeah, so I'm thinking very much about legal education right now because I just taught a class this morning. So I'm thinking about training lawyers. And when you train a lawyer to see difference as well as similarity. You train lawyers to distinguish cases. And so part of the reason that I outlined kind of the primary issues in the Fearless Fund case was to say, this is what got Fearless Fund in trouble. In the 11th Circuit, how can you avoid some of the characteristics that the 11th Circuit hung its decision on? The primary one that I identify is the contract piece, right? Instead of granting money in exchange for something else, right? The name, image, and likeness, and the use of the ideas. How about like no strings attached grants, right?
Restricted funding.
Right. I mean, so no contract created. Section 1981. one is inapplicable. And second, I would say that's the 11th Circuit. The 9th Circuit, the 2nd Circuit, the 7th Circuit are different circuits. In fact, the case was 2-1, meaning that 2 judges were in the majority, 1 dissented. So it's a close one, right? It was a split court. I imagine that case would have come out differently if it was in the 9th Circuit and the 7th Circuit and the 2nd Circuit. So if you're operating within those circuits, you are facing a much less hostile court than you would be if you're operating, say, in the 5th Circuit. So and the last thing I'll say, I'm looking at the clock here, is that what Fearless Fund, what Edward Bloom, what the entire GOP wants is for us to stop talking about race. They want, if you are doing this work, to do it in a colorblind way. But I find in all of my scholarship that I've been writing for the past decade and a half, I find that ignoring race in a country in which race matters, racism works to overdetermine people's life chances, their experiences, whether they live or die, whether they'll grow old or not. It's an error to not talk about what you're doing when we're talking about race in a country in which race is so very salient. So I would not distinguish what you're doing in terms of Fearless Fund said Black women, so we're not going to say Black, but we're going to target Black women. I wouldn't do that. I would be explicit. Know your vulnerabilities, know what circuit that you're operating within, avoid contracts, and then see how it goes. And you are able to shoulder the risk much more than smaller foundations would.
Do we have questions from the audience about the topic? Yes, in the back. I think there's a mic coming toward you, too.
I heard that part, yes.
Yes. I was like, I cannot say that. I'm sorry. Appreciate that. I'm really just curious, right, because we come into these conferences and have these conversations. When I look at kind of ecosystems, I come from movement ecosystem. I'm a co-founder of BYP100, which is one of the Black organizations that helped to found the movement for Black lives. And that's my political home and space is my Black folks, especially my queer, trans women and thems, right? Mm-hmm. But when I look at what folks are doing on, I'll say just the general other side, mm-hmm. is that they don't think about risk in the same way that we do. Mm-hmm. And what I find hard in philanthropy sometimes is these spaces is the people that are usually fighting the hardest are the people that are closest to the work, right? So I'm not shocked to hear about new media ventures and saying, yes, push back in that way, because I'm like, yes. I see the same thing when I look at other funds, like Emergent Fund, right, that is led by folks that have lived similar lives and experiences, while traditional philanthropy and larger groups are left in these positions where folks aren't pushing back in the same way. And I just think that we're at the point right now where if we keep moving in this way, the money that every single institution here combined controls will outlive our communities. I know it will outlive mine. Mm-hmm. So I'm just curious in this moment, what's the big, bold push? Or how do we push and find the spaces where folks are willing to not just accept the risk, but run into the risk?
Mm-hmm. The big, bold push. Martin, do you want to take that?
Not put all his things aside.
What's the big, bold push? I appreciate the question. And it's hard for me, honestly, to answer it because I don't know any other way than having to push. Mm-hmm. And so I think that, to Carlisia's point, we need folks who are not affected by the struggle taking up the struggle. And that would be my suggestion.
Carlisia, you pointed at Martin, but did you also have it?
Just put it on me.
Shit, I'm sorry. I'm sorry, Vance. I really do apologize. You're over there now. I think that we move mountains with money in this country, and we're here talking about capital. So, as much as we treat climate, as much as we teach education and all these other sort of issues as sort of singular problems, we should also lift this up as a singular problem. Who's going to be going to put in the $2 billion initiative that supports closing the capital gap for Black women founders, right? So my big bold push is more money, more loud money. As much as we're doing press forward, let me see, $500 million also toward Black founders who have never received, or Black women founders who have never received more than 1.6% of capital allocated in this country. So I have nothing more than moving more money.
Well, and as Hugh was saying, there will be a session tomorrow with a deeper, with an opportunity for a deeper discussion on these very topics. It's with Leah Trusty of the Democracy Fund, Sonia Childress of Color Congress, and Eloy Ortiz Oakley of College Futures Foundation. There'll be a lot of opportunity for audience engagement, problem solving, lesson sharing, forward thinking. So definitely go to that if you want to continue this conversation. But for now, please thank me in thanking. Please join me. Don't thank me. Please join me.
We thank you, Mina. We thank you. Thank you.
Thank me. And please join me in thanking Kiara Bridges, Carlicia Graham, and Martin Reynolds for being up here, fighting the fight.